Hello, good afternoon, guys. Hello, good afternoon. I hope you guys are doing great. I'm happy to be live today. We have some exciting discussions to have. We have, very exciting discussions that we're going to be having this afternoon. So, guys, join me, jump on this live, and let's get started. I can't wait to spill all the tea. So yesterday we talked about the public charge, and there's a lot of confusion and misinformation going on. So I wanted to bring you some more clarity on the legal position of the public charge rule as well as the public charge statute. Welcome, guys. Welcome everybody that joins us. A big welcome to you guys. Okay. So let me share my screen, and then we're going to be having some fun with this public charge discussion. Okay, guys, so as we all know, yesterday, March 9th, or was it? Yeah, it must have been yesterday. The DHS, Department of Homeland Security, stated that they were going to, the public charge final rule was no longer going to be applied to, applications. Okay, so people were jubilating and all of that. That's really exciting. But I wanted to go into the difference between the public charge final rule versus the public charge inadmissibility statute. Okay, so guys, there's a difference. So you have to know the difference. And the difference is that the public charge inadmissibility statute is still valid. It's still in effect. It's still in the statute books. So I have my Immigration and Nationality Act, the statute right here. And so we're going to be taking a look at some of the things happening. I don't know if you guys can see the public charge section here, right here. Section 2124A of the Immigration and Nationality Act. So let's get into it. So this public charge inadmissibility statute has been in effect since 1882. So it's been in effect for centuries. It's not a rule that just came with President Trump, ex-President Trump. The Immigration and Nationality Act has had this inadmissibility statute enshrined in it for the longest time. And so the inadmissibility statute, being a public charge, it just meant that anybody, I'm going to just be discussing, I won't be reading, don't worry. So anybody that was found likely or liable to be a public charge here in the U.S. would be inadmissible. So you could be deported, or you would not be, you cannot adjust your status, or you will not be granted a visa to come into the U.S. Welcome, guys. Drop me a comment, show me some love, okay? Let me know I'm not talking to myself, as usual. This is interactive, so drop me some comments. So that's what Section 2124A, stipulates, that anybody who's likely to be a public charge is inadmissible. That has not changed. What changed was the fact that in 2019, during the reign of ex-President Trump, what he sought to do was give an administrative definition that broadened, the definition of what it's meant to be a public charge. Okay, so that is what is referred to as the August 2019 public charge final rule. Okay, so the public charge final rule made the definition broader. It included, non-cash benefits as well as other things, as opposed to the public charge inadmissibility statute, which had a very narrow meaning. And so let's just go over a little bit of background. I don't want to bore you guys to death. I hope you guys are enjoying this live video. And let me try to scroll up, and then let's see what's happening right here. Okay, I would have to go to the main text. Hold up. Let me pull this up right here. Where is it? Okay, I found it right here. So we'll do a little bit of background and then we can move on. Okay. All right, guys, let me open up this screen right here. Okay, so the background is this, that November 2nd, 2020, the U.S. District Court for Northern District of Illinois, they vacated the inadmissibility on public charge grounds final rule. So the public charge grounds final rule, you know, the court decided, when they say the court vacated, it just means that the court overturned or stopped it. So they vacated it at that time means that the public charge rule was no longer required. However, subsequently in October 2nd, 2019, this decision was stayed by the Seventh Circuit. You know, you'll see it right here. This decision was stayed by the Seventh Circuit, the Court of Appeals for the Seventh Circuit. What it means is that even though the public charge ground was off, it was stayed. It means it was temporarily suspended. Now the public charge was back on. This was October 2nd, 2019. And then, you know, the next thing we know, March 9th, 2021, there was an order, you know, so the Seventh Circuit lifted its stay. And the U.S. District Court for the Northern District of Illinois, Illinois' order vacating the public charge rule went into effect. So when we say that, it just means that the public charge rule was again voided. It was stopped. It was overturned. So that's been the series of events, the sequence of events that have happened. All right, guys. So let's go back to welcome, guys. Welcome. We're spilling some hot tea. Guys, stay with me. It's going to be fun. We're breaking a lot of things down today. Let's go to this. Let me add this to. I'm going to add another. I'm going to share another document, and we're going to be looking at a very interesting aspect of the law right here. Is it this final rule? Not this one. Okay, let me see. Where is this? Okay, great. I found the Federal Register inadmissibility on public charge ground. This is exactly what I was looking for right here. Oh my goodness. I don't think this is what I'm looking for. I'm sorry. I don't know what's happening. Hold on, guys. Stay with me. Oh, I found it right here. Okay, so the gov info. Okay, that's what I'm looking for. Not this. Let me take this off. Welcome, guys. Drop me a comment if you are here with me, and then I can share you know, the screen I'm looking for. Drop me a comment as we pull up the screen right here. I'm just having a challenge trying to pull out the exact screen. Where is this? It's FR. Oh, great. I found it. There it is. Not this. Why? Oh my goodness. I'm having some technical challenges right here. Oh my goodness. Well, let me go back to the screen and then see what is going on. Guys, stick with me. Please stick with me. We're just going to be, I'm just trying to share this other screen and it's proving a little bit difficult. Okay, great. Oh my goodness, I found it. Yes. This is why I was struggling so much. Okay, so it's right here. Okay. So we're going to be going into the definition of what the public charge rule was, and then what ex-President Trump sought to do, the changes he sought to bring, and then we can we can discuss that very well. I'm so sorry. Today is a tough day. I don't know why my screen is just being so stubborn. As stubborn as me, right? Yeah, quite stubborn. Okay, guys, so we're back. That's it. Let me open it. Okay, so this, what I have here is the 1999 Federal Register. So the public charge definition was provided and was given in the federal, was defined in 1999. And what ex-President Trump sought to do in 2019 was to broaden the definition. And now the U.S.CIS, that's United States Citizenship and Immigration Services, has reverted to the old definition. So we still have, as I keep telling you, we still have the public charge statute, but no more the public charge rule. So let's go to the main definition of what the public charge statute says. That rule proposes that public charge means an alien who has become, for deportation purposes, or who is likely to become for admission or adjustment purposes, primarily dependent on the government for subsistence, as demonstrated by either one, you are receiving public cash assistance for income maintenance, and two, institutionalization for long-term care at government expense. Okay, so note this definition. Guys, let me sip my hot tea. As usual, we're sipping hot tea. Sipping and spilling all the tea. So the definition just meant, number one, you were receiving public cash assistance for income maintenance. So, for example, every month you were receiving money from the government that, oh, I'm not working, give me, say, whatever, say $200 every month. That was public cash assistance. That constituted public charge. You were a burden onto the U.S. And for the purposes of the public charge inadmissibility statute, you were not admissible to the U.S. The second one was that you were going to be institutionalized for long-term care at government expense. So, for example, you have some disease, some really rare disease, and you had to be in the hospital for a while, some months, and all of this was on the government's pocket or on the government's account. And the government had to provide you with insurance and, with care and all the medicines and all the reviews and checkups. So when we had these two conditions, you were likely or liable to be a public charge, and so you were inadmissible. This is what we are reading right now is straight from the Federal Register 1999, which is what the U.S.CIS has stated that they're going back to. Okay, guys, you get the distinction. I hope you guys are having fun. We're spilling hot immigration law tea. Drop me a comment. I'll be reading comments soon. Let's just get into the law. So what they're stating is that institutionalization for short periods of rehabilitation doesn't constitute, such a public charge. So guys, we have gone to the 1999 public charge definition. Okay, so now we're going to go back to the U.S.CIS website, where we're going to be seeing what is in place now, what is happening now, what they are stating now, and what the scoop is. Okay, so all right, right here, there you go. We got it. Okay, let's come this way. So guys, they're stating that the U.S.CIS has stopped applying the public charge final rule to all pending applications. So as distinct from the public charge statute, inadmissibility statute, the final rule by President Trump, as I said, was the one that sought to broaden the definition and now has made, even non-cash assistance makes you a public charge. Okay, the 1999 definition, and according to the statute, it was just cash assistance if you're receiving money from the government, and number two, if you're going to be institutionalized, for a long term on the government's pocket. But former President Trump included non-cash benefits. And so if you received some sort of housing benefits, if you were receiving food stamps, if you're receiving Medicaid, SNAP, and a whole lot of other benefits, it didn't have to be cash. That's what President Trump President Trump brought about a new administrative definition to what the public charge meant, and that is what is known as the public charge final rule. Now we're reverting to the 1999 public charge definition, which is what is in the statute. The Public Charge and Admissibility Statute is now in place, and of course, they still also consider, the statutory minimum factors in the totality of the circumstances, but the definition is not going to be broadened as ex-President Trump sought to do. And broadening the definition meant that lots of immigrants were going to be caught in the net of inadmissibility, right? That was the whole point. Now we're narrowing it back to the 1999 definition, which was very limited, and it just meant cash assistance and institutionalization for a long period of time. Okay. Okay, guys, so now let's go to the second part of this video. We're going to be talking about if you have received an RFE, that's a request for evidence, or you've received an NOID, that's a notice of intent to deny, what you should do. Remember, this is not legal advice. I'm, just educating the public. If you want specific legal advice for your situation, make sure you give me a call. My number is right on the screen, 802-7800-564, and then I'll be happy to help you. So if you've received the public, number one, if you are even making any application, don't submit form I-944, which is the form for declaration of self-sufficiency. That was the form that was crafted, to be able to test ex-President Trump's public charge final rule. Okay, don't submit it because it's no longer in effect. In fact, when you try to even log on to the website and try to pull up form I-944, the form has been deleted. It can no longer be found. Okay, so that means that applicants for adjustment of status should not submit form I-944 or any evidence required by form I-944 when they file their I-485, which is the adjustment of status. Applicants and petitioners for extension of non-immigrant stay and change of non-immigrant status should not provide information related to the receipt of public benefits on some of these forms. So no need to provide, because they'll tell you, they'll ask you what did you receive food aid, medical aid, and you had to provide information relating to the receipt of whether you received all these public benefits. Now you don't need to do that anymore. You just simply need to just disregard. No more public charge. No more public charge. Also just disregard anything related to that. Let's go to the next portion of this. And so if you received an RFE or a NOID, a notice of intent to deny, requesting information that is solely required under the public charge final rule, and your response is due on or after March 9th, you don't need to provide that information. Okay, so look at your RFE, look at your NOID. When is your response due? If every NOID and every RFE has a deadline. So if your response was due or on March 9th, stated in there that your response is due or on, then don't provide anything related to the public charge rule. But remember that you have to look very critically at your RFE and the NOID, notice of intent to deny, and the request for evidence. If it pertains to eligibility for the immigration benefit sought, if it pertains to any other thing, then you need to respond to those aspects. Okay, you need to respond. So, for example, if you're doing a petition for alien relative, and the I-130, and you're doing a concurrent filing, the I-130 and the I-485, because your relative is right here in the U.S. Remember that if you've received an RFE that says, look, we need more evidence on the fact that this person is really your child, you need to respond to that. It can come with an RFE that also states that you stated that you receive public benefits on so and so dates. Give us evidence of, give us more information about that. Do not respond to the part of the RFE that is asking about the public charge inadmissibility determination. Okay, so it says that you do need to respond to aspects of the RFE and the NOID that pertain to the eligibility that you're seeking. If the U.S.CIS requires additional information or evidence, to make a public charge inadmissibility determination under the statute and consistent with the 1999 definition, they'll issue another RFE or NOID. As I stated, remember, go back to what I told you. The public charge inadmissibility statute is still in effect, guys. It's still very much grounded and crafted in the Immigration and Nationality Act right here. You look at section 212. So this is this is my statute, section 212 of the Immigration and Nationality Act. Section 2124A, the public charge, whether you are likely to be a public charge, is still very much an assessment they're going to make, because this statute was implemented in 1882 as far back. Anybody that is likely to be a public charge, according to U.S. immigration law, you were inadmissible. A public charge definition, according to the 1999 interim field guidance, means somebody who's receiving cash benefits and will be institutionalized for a long time on government account. Okay, guys, so that's really the scoop. Just note the difference. Public charge final rule is gone. However, the public charge statute is still very much enshrined. You know, the public charge, the rule on public charge is still very much enshrined in the statute, the Immigration and Nationality Act, that actually, you know, gives us the do's and don'ts of U.S. immigration law. I hope you guys have benefited so much from this video. Let me just pull out this and then let's see. Guys, drop me a comment, show me some love. Oh my gosh. Today the feed is a little dry, but yeah, it's to be expected. When I'm spilling the legal tea, it's serious business. When we're just spilling immigration law news, you know, it's just fun times. But the legal tea requires a lot of analysis and discussions and, you know, breaking down the law to make sure that we all understand what's going on. So guys, drop me a comment. Let me know where you're watching me from and whether you lost me or whether, well, I lost you. Well, yeah, whether you lost me on anything you want clarification on. And I will be happy to give you the feedback. Okay. So guys, final point, number one, the likely to be a public charge is still an inadmissibility ground in the Immigration and Nationality Act. So if you're likely to be a public charge, unfortunately, you are still inadmissible. Okay, you're still inadmissible to the US. And the administrative definition is very narrow. It has to be public, you know, cash benefits or you know, being institutionalized for a long time on the public account, on the government account. So institutionalization could be, you know, if you're in a hospital because of a big illness, or you are in rehab and you are institutionalized, or you are in a mental facility and you're going to be there for a long time, and the government has to pay for your medicine, your x-rays, your therapies, just, you know, all of that. Then you're a public charge. The public charge final rule that ex-President Trump sought to broaden is gone. So now non-cash benefits are not part of the public charge. If you've received non-cash benefits, you are not necessarily considered likely to be a public charge. You know, this became an issue during the coronavirus, because people were very worried that, look, I mean, why would President Trump do this? That means that people who even have coronavirus that don't have documentation would not go to the hospital to be treated, because they're like, look, they'll think I'm a public charge. And so, you know, so thankfully that was even excluded. If you had coronavirus and you needed help, that was excluded from the preview of the law. So you were not considered a public charge, even under Trump, if you had to, you know, seek medical treatment because of coronavirus, because that was a public health crisis, and that could spark some issues. So basically that is the difference. If you have an RFE and a NOID concerning this and you need help with interpreting and knowing exactly what you should do and what you should submit, please call my office on 802-7800. 564 802-7800-564, and you will speak with my very friendly legal assistant, and she will schedule you for a consultation where you don't leave without a solution to your issue. You don't leave without an action plan. Guys, I'm here for you. I handle all types of U.S. immigration law matters, and I serve clients and I represent clients zealously. It doesn't matter where you are in the U.S., all around the U.S., I will represent you. And yeah, so just get in touch if you need help, and I'll be ready to assist. Guys, let me know who and who was where on the live. Drop me a comment, guys. Show me some love. Well, we will call it a day. I will be back again to discuss some more legal matters and, spill some hot tea with you, hopefully tomorrow. I hope you guys had fun and you have benefited from this live session. Well, I will say that take care of yourself. Don't forget to be safe, love the people around you, be kind, and, spread some good love. And take care until we meet again. Bye-bye.